How's everybody doing? Just getting things set up here, you guys, and then we're going to go over what this is going to cover today. Give you a little bit of backstory here as we're waiting. Hello, Marie. Hello, Dawn. Hello, everybody joining. The actual court hearing is going to start in about 25 minutes, but I wanted to start a little early so I can go over what we are going to hear today when the court hearing starts in about 25 minutes. Okay, so hello, everybody coming in. Please hit that like button on your way in, and please make sure you have live chat selected at the top of your screen so you don't miss anything. Hello, Cleta. Oh, thank you. Thank you. Such a sweetheart. Thank you. Good morning, Marie and Dawn. Good morning, everyone. Yes, Marie, I'm glad to hear that the puppers is getting better. Okay, so let's get into this for those who maybe have not heard everything about this case. This is the lawsuit that's been filed by Gabby Petito's family against the parents of Brian Laundrie. And that hearing is going to start in about 25 minutes. And it's going to determine if the case is going to proceed to a jury trial next year. Hello, Tanya. So the judge is going to hear arguments from both sides. Oh, thank you. I appreciate that, Cleta. It really helps with the channels. So thank you so much for that and for showing your appreciation. Okay, so the judge is going to hear arguments from both sides. Whoops, I'll leave that up. From the attorneys for both Chris and Roberta and from the Petito family. Hello, Kat H. And the lawsuit was filed in March by Petito's parents, Joe and Nicole. They filed the lawsuit on the grounds of intentional infliction of emotional distress. Hello, Lorna, and welcome. Claiming that Brian's parents were hiding information and that they were aware that Brian had murdered their daughter and chose not to act. The lawsuit also claims that Chris and Roberta sought to help their son flee the country and block Schmidt on the phone and on Facebook. Hello, Sonia Kapel. Hello, everybody. So this is what the hearing is going to be about today. Like I said, for those coming in, it's going to start in about 20 minutes now, and I will bring you that live. I'm just going over what this is going to be about. So they're going to argue their cases. And the judge will decide whether this is going to go to trial. Earlier this year, the FBI concluded that Laundrie strangled Gabby, so that Brian strangled Gabby, his fiance, with whom he had at least one previous domestic incident with during their cross-country trip, and that Brian died of a self-inflicted gunshot wound to the head on the Carlton Reserve after returning home alone on September 1st. So today's pretrial hearing, which is going to start, like I said, in about 20 minutes, is in Sarasota County Circuit Court in Venice, Florida. So it's going to be the first time the Petito case reaches a courtroom. And the judge is going to make a decision whether this is to proceed to trial or not. The Petito family also claims to have evidence. So the lawsuit includes an allegation that Chris and Roberta were told by their son of Gabby's murder on about August 28th. Hello, Kat H, Jakey, History Underfoot. Hello, everybody coming in. It's believed and therefore averred that Brian Laundrie advised his parents, Christopher and Roberta Laundrie, that he had murdered Gabby Petito. And that's what the lawsuit states. On that same date, Christopher Laundrie and Roberta Laundrie spoke with attorney Steve Bertolino and sent him a retainer on September 2nd. What the lawsuit doesn't include, though, at this stage, however, is any evidence to back up the claim. Hello? So, whoops, sorry, you guys, that's my phone going off here. Just give me a second, you guys. That's my sister Des. Give me 1 second. Okay, sorry about that. I just had to reply to her there. I don't know. I haven't really looked into that, Butterfly Dana. Hello, Merritt. Hello, Christy. Hello, everybody coming in. Nice to see you all here. Okay, so I know that they did add other stuff after they filed this to the complaint to beef it up. We'll have to wait and see what that's going to include and what that is going to say. It also goes on to say that Chris and Roberta were never charged by authorities during the FBI's investigation into Petito's death. But in October, however, Northport Police, Josh Taylor, said that NPPD investigators had mistaken Roberta for Brian in September due to lack of cooperation from the Laundrie family early on. So the Laundrie lawyer is saying that his clients cooperated with law enforcement and that their choice to remain silent to the public, including the Petito and Schmidt families, is protected under the U.S. Constitution. Hello, Ryan. Christy. Hello. Bordolino is also saying that the Laundries did not publicly comment at his direction, which is their right under the law. And he's saying, assuming everything in the Petitos are alleging in their lawsuit, even if it's true, which they deny it is, the lawsuit doesn't change the fact that the Laundries had no obligation to speak to law enforcement or any third party, including the Petito family. Now, the Petitos have several people on their witness list, which is Joseph Petito, Gabby's father, Nicole, Gabby's mother, Tara Petito, which is Gabby Petito's stepmother, James Schmidt, which is Gabby Petito's stepfather, Christopher Laundrie, which is Brian's father, Roberta Laundrie, who is Brian's mother, representatives of the FBI, and representatives of Northport Police Department. The Laundries have so far filed 2 motions to dismiss the lawsuit, but the judge has decided to go ahead with this pretrial anyway to see what they actually have. Hello, Butterfly Dana. The amended complaint did not have any new facts or cite any law that would support the Petito's legally based claim, is what the Laundrie's lawyer is saying. So there's going to be a pool camera that's set up that we can stream, from what I'm understanding. So that's what I am waiting for. Okay, and it looks like it's underway, you guys, so let's get going on it. Okay, let me just see here if it's started already or if they're just getting into the courtroom. Okay, it hasn't started yet. But everybody, Gabby Petito's parents are in the courtroom. So as soon as it starts, you guys, when the judge comes in, I will start this. Okay, so also just a little bit of backstory before this starts, you guys. Everybody is in the courtroom. I will bring that to you as soon as it starts, so you can watch the trial yourself. So what Gabby Petito's parents are saying is what was supposed to be a dream trip for the young couple turned into a nightmare. Okay, so I'm going to start over, you guys, and just give you the timeline. July 2nd is when Gabby and Brian started their road trip. They left Blue Point, New York, in Long Island on July 2nd for a cross-country road trip to national parks out west in Colorado, Utah, and Wyoming. They were documenting all their steps, taking pictures, photos, and posting them. August 12th, there was that argument in Utah. So just over a month, I guess, into their road trip. August 12th, Petito posted photos twice on Instagram from a visit to the Arches National Park in Moab, Utah. On that same day, Moab police responded to a witness's report of an argument and physical altercation regarding the couple. The Moab police decided the fight didn't raise to the level of domestic assault, as much as that is maybe some mental health crisis, and that police just recommended the couple spend the night apart. Petito stayed in the van, and Brian got a motel room. So then on August 17th, which is 5 days later, Brian flies home to his parents' home to obtain some items and empty and close a storage unit to save money as they contemplating extending their road trip. August 21st was Gabby's last FaceTime with her father. So 9 days after the reported incident in Moab on August 21st, Joseph Petito said that he had his last FaceTime call with his daughter. He said he helped order her food in Salt Lake City. He said no red flags popped out. August 23rd, Laundrie returns to Salt Lake City where Gabby was to rejoin Gabby after he had already flew home to Tampa Bay. On August 25th was Gabby's last phone conversation with her mother. And she had said that she was near Grand Teton National Park in Wyoming. She was trying to contact her, but wasn't getting any responses. And she just believed that they were in a place that had no service. But after 8 or 9 days, they became concerned. But on August 27th, Petito sent an odd text to her mom that left them worried, because it was something about calling her grandfather by his name, which she never did. On August 30th, Petito's mom says she got a final text. And then from August 30th to September 1st, Brian uses Gabby's debit card. And that was on his way back to Fort Lauderdale or Tampa, or wherever he was going to his family's. That's when he was going back there with Gabby's van without Gabby. So on September 1st, Brian returned home to Florida. And according to a search warrant, a license plate reader at the Sumter Boulevard exit of I-75 detected the white van entering the city of Northport at approximately 10:26 a.m. on September 1st. On September 4th, Brian Laundrie purchased the new phone and opened an account with AT&T, according to the lawyer Stephen Bordolino. September 6th, they go on a camping trip. We all know about that, where Brian goes with his mom and his dad. His sister and her husband and their kids show up. They have a little camping trip for 2 days. September 10th, Petito family calls Northport police to file the missing person report. September 11th, Petito was reported missing. And don't forget, during this time, they had Gabby's parents have been trying to contact Brian's parents, and they ended up getting blocked, and Brian's parents refused to speak with them. So they finally reported her missing. I'm just checking the court there, you guys. So on September 13th, Brian leaves the home. And he was mistaken for his mother was mistaken for being him. So they thought that he had returned home. Whoops, I just lost my sound. Hang on a sec, you guys. Okay. Okay, so they're still talking over there. Sorry about that, you guys. The Laundries were basing the date Brian left on the recollection of certain events. Upon further communication with the FBI and confirming of the Mustang being at the Laundries' residence on Wednesday, September 15th, we now believe the day Brian left to hike in the reserve was on September 13th. Do you remember that the parents of Brian went looking for him, found the car at the reserve, and they took it home? So September 14th, the abandoned vehicle notice was posted. September 15th, Brian Laundrie was named a person of interest in missing Gabby Petito. September 16th, Petito's family begs for help, but it was all turned down. The Laundries would not speak with them. On September 17th, Brian's parents reports him missing now, saying they don't know where he is. September 18th, the search starts for Brian Laundrie. Hang on a sec, you guys. Okay, so the search for Brian Laundrie starts on September 18th because his parents had reported him missing the day before. On September 19th, Gabby's body was found in Wyoming. September 20th, the police tape off Laundrie home and start going in and searching the home. September 21st, the search for Brian Laundrie continues, and Gabby's body was identified. On September 23rd, there was a federal arrest warrant issued for Brian, and that was for using Gabby's debit card. September 24th, Dog the Bounty Hunter joins the search. September 25th, FBI visits Laundrie family home and takes personal items of Brian's to aid in the ongoing investigation. September 26th, the Laundrie search scales back. September 29th, FBI obtains Brian Laundrie's phone and some surveillance video. September 30th, the agents then checked the camper, which I believe should have been checked right away, but they didn't. Again, the search for Brian Laundrie starts ramping back up on the reserve on October 6th. They said that it had been flooded, so they couldn't get into it, etc., etc. October 7th, Brian Laundrie's dad joins the search. On October 12th, Gabby Petito's cause of death was released, and it was believed that she had died 3 to 4 weeks before her body was found. So that would be about the time that Brian had left. October 20th, partial human remains were found in the Carlton Reserve. The next day, they were identified as Brian Laundrie's. November 16th, Gabby Petito's parents go and do a podcast on WFLA Now and get a lot of support. November 23rd, Brian Laundrie's autopsy findings were released. And then January 21st, the FBI releases its investigation findings, and it relieved that Brian Laundrie was the only person believed to be involved in Gabby's death. And then here we are now with the case. Oh, thank you, Butterfly Deanna. I'm just looking, I'm checking to make sure this hasn't started yet. You guys, it hasn't. It should be starting any minute, and I will be bringing that to you. Oh, Marie says, I'm back. Monsoon like thunderstorms. Yeah, we're supposed to be getting that this afternoon, Marie. Oh, Kat, I'm sorry to hear she had to go through that too. The pretrial is happening in Venice, in Sarasota County Circuit Court in Venice, Florida. Yeah. They can still plead the fifth, but at the deposition that would happen, that's when things would come out. They could get on and they could do the same thing today. They could get on and plead the fifth. So, but once, if they're sent to deposition, then they're going to have to speak there. So apparently the Laundries have a couple other new lawyers. Okay, let me see if I can't get into this hearing myself. Hang on. It's saying that it can be shown, so let me see, you guys, if I can get into the, instead of 0. Because I was sent a passcode and everything, so. Okay, it says, please wait. The meeting host will let you in soon. So if I can't get in myself, I do have another stream of it. But I'd rather stream it. Oh, there we go. Okay, I've got it, you guys. I'm in. Oh, crap. Hang on. Okay, so let me just check and make sure my audio is turned off. Okay, I think my audio is off. Okay, hang on, you guys. I'm just trying to get this set up properly. Oops. Okay, you guys, I've got it up here. Let me just share.
And good afternoon.
Okay, please press 1 if you guys can hear it.
I am electronically present in the courtroom today as I'm abiding by the court's quarantine protocols. We have technology in place to allow the court's work to continue without delay. My preparation for all hearings today, not simply these 2 cases, has been the same. The court is prepared. Whether you are joining us in person in the courtroom or via Zoom, welcome. There are 2 housekeeping items to address. First, only credentialed media authorized by the court's public information officer, as well as the court reporter, may record these proceedings in the courtroom or on Zoom.
Okay, I gotta get out, guys. If you have not
received that authorization in advance, you may not record these proceedings.
Okay, I gotta get out. Hang on. So, hang on, you guys.
Only credentialed media authorized by the court's public information officer,
so I'm gonna have to share it from here,
as well as the court reporter, may record these proceedings in the courtroom
you guys know
or on Zoom.
Okay, can you
If
hear
you
it?
have not received that authorization in advance, you may not record these proceedings. Second, we have 2 cases this afternoon. The first case we will address involves the parents as parties in the lawsuit. We will complete that hearing before moving on to the second case, which is the case involving the estates. So let's begin. The court's going to first call the case of Joseph Petito and Nicole Schmidt versus Christopher Laundrie and Roberta Laundrie, case number
I wanted to do this
2022
myself, you
CA
guys, but
1128.
I'm going to follow the
Ask the
law, even
attorneys
though
to
I'm in
please make their
Canada.
appearances and introduce their clients if they're
I am
present.
following the law.
Patrick Riley Ford, sitting to my right, Joseph Petito, and also sitting to my right, Nicole Schmidt.
Thank you. Mr. Luca?
Good afternoon, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie, who are not present.
Thank you very much.
Oh, they're not present,
Now we are
you guys.
to hear the motion to dismiss filed by the Laundries, which is at document identification number, or DIN 33. The plaintiffs have filed a response, which is at DIN 38, and the defendants have filed a reply, which is at DIN 39. I've reviewed those filings as well as the other materials submitted by the parties. So, Mr. Luca, you have the floor, and if you'd like to go to the lectern, that would be great.
Yes, thank you, Your Honor.
I have to say, Your Honor, it's unusual to be staring at an empty spot up there at the bench.
Well, it is what it is.
What do they tell actors, Your Honor? Just find a place on the wall and stare at that? Well, thank you, Your Honor, for your time this afternoon. I appreciate it. Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that, so I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing, who has no contact with the plaintiff. All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise and show why there is no legal footing for this cause of action in this context. Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct was found to be intentional infliction of emotional distress. Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak. The law imposes no such obligation to speak, and the state and federal constitutions support that. In our society, under our laws, people are free not to speak. Your Honor, the elements of the cause of action alleged are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not conduct is outrageous is that the behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society. It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Now, Your Honor, looking at the amended complaint in this case, paragraph 32 provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege first, failing to advise the plaintiffs that Ms. Petito was deceased. Second, failing to disclose to the plaintiffs the location of Ms. Petito's body. Third, taking a family vacation with their son, Brian Laundrie, who they alleged had murdered Ms. Petito while the plaintiffs were looking for Ms. Petito. Fourth, blocking access to their cell phone and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Ms. Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family.
Is there a distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case, and there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to making that statement. So I do believe that there is a distinction, Your Honor.
Isn't under Florida law, isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor, what we don't know, what is not alleged in the complaint is whether their attorney was making that statement on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well, on a motion to dismiss, how am I supposed to construe the well-pled allegations?
Your Honor, on a motion to dismiss, I would argue to the court that by not alleging in the complaint that the attorney was the agent of the plaintiff, or, I'm sorry, of the defendants for purposes of making that statement, that the plaintiffs have not alleged sufficient conduct that would cause liability for the defendants for the statement by their attorney.
Well, assume for the sake of argument, the court concludes that there was sufficient allegations that the attorney is the agent for the Laundrie. So assume that to be true. Now we have a situation where the Laundries themselves are making a statement and not standing silent. So what does that do to your argument about staying silent?
Your Honor, I still don't think it necessarily makes a difference. I mean, I understand what the court's saying, that that if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak. So again, Your Honor, in my view, the attorney was merely exercising the constitutional rights of both the attorney and of his clients by making a statement.
Okay, but when you make an affirmative statement, that's the antithesis of staying silent, right?
I would agree with that, Your Honor, yes.
You may continue.
Thank you. Your Honor, the plaintiff's claim of outrageous conduct in this context is novel. The plaintiffs have cited no cases where a person's silence except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous, regardless of the circumstances. And they certainly haven't cited any cases where a statement by a person's attorney has been considered outrageous. All of the cases they've cited involve some action by the defendant. Accepting the allegations of the amended complaint as true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge. And that is simply not something that our legal system requires. For example, if a family member came to me and told me that they did something terrible, the plaintiffs want the law to impose an obligation on me to then report what that family member told me. And that just isn't the law. Even if that, I'm sorry, go ahead.
Let me make sure I understand what you're saying. Are you saying that they came to you in your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Okay, well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent, a child, a wife, a husband, just anybody. My argument is not that there was a privilege between Brian Laundrie and his parents. My argument is that even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak with regard to that information. They don't have to share it.
I fully understand.
Well, let's go down that road for a
The
moment.
Constitution is
Right.
This is where I'm having some difficulty.
That being said, we're on a
fully
motion to
understand and
dismiss
get
on the constitutional right to remain silent. That being said, we're on a motion to dismiss on a complaint where I have to assume the facts are true. And you're trying to get me to say that the complaint itself demonstrates the existence of a right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative defense that should be fleshed out in the pleadings?
Your Honor, I don't agree that it's an affirmative defense that needs to be fleshed out. I believe the court can, obviously the complaint alleges that the defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution of the United States apply to them. And if you look at the complaint, Your Honor, even though it doesn't allege a formal criminal investigation, it doesn't use those magic words, so to speak, it does allege that Brian Laundrie murdered Miss Petito. It alleges that Brian Laundrie engaged in conduct to try to cover that up by sending text messages and things like that. It alleges that the defendants, his parents, the Laundries, were trying to help him escape the country. It alleges that the Laundrie family hired an attorney, and then once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor, that's enough for the court to say somebody in that situation could invoke their Fifth Amendment privilege. That's not something that the court would need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations within the complaint that would trigger somebody in that situation exercising their Fifth Amendment privilege. Your Honor, would you prefer for me to continue with the outrageous element or move on to the legally permissible element, since that seems to be
Whichever way you want to go.
Okay, thank you, Your Honor.
I'm not shy in asking questions.
I understand. Your Honor, the plaintiff's cause of action could also extend to somebody who, may not be in the situation where they were told something, but maybe they witnessed something, or maybe they came upon some evidence, or somehow they had some information that might be relevant to some tragic event. The plaintiff's cause of action would impose an obligation on people like that to contact the families who may be involved in that situation and disclose what they knew, or they would fear being sued. The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability. Now, the underlying crime.
But again, I go back to, there's an allegation that the Laundries made an affirmative statement and put out into the public various statements. So am I not supposed to consider that conduct because that's a voluntary act by the Laundries?
I understand, Your Honor. And I assume you're referring to the one statement by the attorney alleged in the complaint. Assuming for the sake of argument that is an affirmative statement by the Laundries, Your Honor, you can definitely consider that. But again, in the context of the overall case, is that statement alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something, but I didn't share other things? That's really the question, Your Honor. Is what are we going to require of people in a situation like this? Are we going to require them to say everything that they know, or are they going to be allowed to speak freely or not speak at all? That's really the question before Your Honor. And Your Honor, I think it's important to keep in mind the standard that we're talking about here, that the conduct has to be atrocious and utterly intolerable in a civilized society. You know, people who are faced with difficult challenges have to make difficult choices. In our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights. And those are choices that our society considers entirely tolerable. And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that's not atrocious. It's not intolerable in a civilized society for their attorney to make a statement for them like that. Your Honor, another thing I'd like to address that the plaintiffs raised in their response is that the Laundries were somehow in an unequal position to the plaintiffs, and that made their conduct particularly outrageous. Your Honor, I don't think that the standard for unequal positions is really what the plaintiffs would qualify that under this circumstance. Your Honor, in Dependable Life Insurance Company versus Harris, which is a 5th DCA case from 1987, it's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is Restatement of Torts, Section 46, subsection E, which states this unequal position argument. And what the restatement says is, the extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with another which gives him actual or apparent authority over the other or the power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. So, Your Honor, in Harris, what the court recognized there is that the result of this unequal position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm. Like, you know, I'm gonna cause you to lose your job. I'm gonna cause you to be arrested. I'm gonna hurt your family, something like that. That's really what it's about. It's about somebody who has some authority to affect the person's life. It's not a situation where somebody might have information that another person doesn't have and they simply don't share it. That's not really what the Harris case or what the restatement are talking about when they say unequal positions. Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme, such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
Aren't we responsible for the words that we say when we say them?
I would agree with that, Your Honor. Certainly, if you say words.
Johnny Depp just got found civilly liable for defamation by what his attorney said, right?
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation. I agree with you on that. I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it is not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but I have to accept it as true. That the Laundries knew where the Gabby's body was, and they put out a statement in the middle of the search, hoping about the success of that search, and then not either directing them or either staying silent. I mean, that's kind of my understanding of what is being alleged. Is that correct, or am I misunderstanding?
No, I believe that's my understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement. That he had that information. That's a totally different thing. They've alleged that the parents, the defendants, had that information, but they don't allege that that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he may or may not have known. It's really all about what the parents knew, and they don't make any allegations about what the parents communicated to the attorney. So really the attorney's statement, again, if just looking at it within the four corners of the complaint, there really isn't enough there to say that whether or not when the attorney made that statement, what his knowledge was about any of the facts of the case, frankly. And I would also submit to you, Your Honor, that statement's fairly benign. I mean, I understand in the context that they've alleged, it could be construed as trying to divert attention or something like that. But again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged what information he had when he made that statement.
Isn't the context really what's important here? And that's what the second DCA said in that insurance case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person. And the second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that case, the second DCA said that the actions of the insurance company in simply denying the claim, even though they had been ordered by a judge of compensation claims to pay the claim, that in and of itself would not have been outrageous. But what made it outrageous was that there was some sort of internal, decision made that they're just not going to pay it for a certain period of time in the hopes that the plaintiff would die. I agree with you that made that particular case, rise to the level of outrageousness. Your Honor, frankly, the statement by the attorney in this case doesn't come even close to that level of outrageousness. I mean, you're talking about, withholding medical care in the hopes that somebody dies so you don't have to pay for it. I mean, I don't think any of us sitting here would not find that to be outrageous. We're talking about a statement by an attorney, sort of, boilerplate and generic, just expressing that he hopes that the search is successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor, that the context is important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
You have about 5 minutes left in your argument.
Okay, thank you, Your Honor. So I'll move forward, Your Honor. I know we filed a motion and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint, they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint. And so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely waive them. If the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here. And one of the cases we cited to Your Honor in our motion sort of sums it up. It's Gerber versus Longboat Harbor North Condo. It's a Middle District of Florida case from 1991. And that court said, defendant's motion to dismiss is predicated upon its assertion that since it is not a governmental entity and has not assumed substantially all of the functions of a governmental entity, the provisions of the First Amendment as incorporated in the 14th Amendment simply do not apply. This court cannot agree with defendant's contention, and by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch of government, the judicial branch, is also state action. This court found and continues to find that judicial enforcement of private agreements contained in a declaration of condominium constitutes state action and brings the heretofore private conduct within the scope of the 14th Amendment, through which the First Amendment guarantee of free speech is made applicable to the states. Now, obviously, we're not dealing with a contract here or a condo association or anything like that, but the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment, and they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment, Fifth Amendment, all of their rights, Sixth Amendment right to counsel. So, Your Honor, in that regard, there is state action. I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before, the Laundries are residents of Florida. It's alleged in the complaint. As such, the Constitution fully applies to them, and the court can consider those rights. The plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings, summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties. Your Honor, with regard to the affirmative defense, nobody cited any cases where the legally permissible element is labeled an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. Rather, the legally permissible element is really intertwined with the outrageous element. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said, the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility for Medicaid, from Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's actions are privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageous calculus, the outrageousness calculus, that the conduct isn't legally outrageous if there is a privilege or a legal right that's being asserted. And Your Honor, we cite some additional cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation where the court can't consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case. And in that case, the court was considering a First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that and not this is not within the four corners. I mean, we know outside of the four corners, but not in the four corners. Is there an allegation that there was an arrest warrant out for him? But assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you might be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I mean, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like I can assert my silence for as long as I feel like I need to protect myself.
Well, let me ask you this, because the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So, for instance, if the question is, "What is your name?" you might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not your Fifth Amendment argument actually is applicable?
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else. There could be, again, we're not leaving the complaint when we talk about that. And so in that regard, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation. If there is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions the defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, like there are certain situations if defendant is subpoenaed to testify, perhaps like, you know, certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is, you know, again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works. It's not the way, you know, it's not how the Constitution works. People are protected until they're not. And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they're able, they can withhold all information until it's compelled of them. That's, you know, or they're provided immunity by the government or whatever the circumstance might be.
Well, let's put a pin in that right now so I can hear from your opponent.
Yes, Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
May it please the court. Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint. And I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question. And I guess maybe by answering this, I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew starting on August 28th of 2021 that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know where their daughter was. Not only did she not.
Let's get back though to legal duty. I hear what you're saying, that these facts might sound bad, but you know, we're not talking about social mores here. We're talking about legal duty.
We're talking.
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. I admittedly, it's difficult to say what it is. And that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion, where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children had been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant, even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, a complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did on behalf of the Laundries here? "We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress," and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, "the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage." In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement, restatement of tort section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we too, we know she was our son's fiance, and we hope that you find that body too, or you find her and the family is reunited. Excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so. Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment does.
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question is, now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive. There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No, it's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor. Are the Laundries suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contact an attorney.
I get back to where's the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm not I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view. That's why it's in the complaint. Goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor.
Thank you so much, April Miller,
another
for your
important
super
case,
sticker. I appreciate it.
MM versus MPS. It's a third DCA
Des,
case from
thank you
1989,
so
again
much.
cited in the papers. And
So
although not
much. I really
perfectly
appreciate it, you guys.
analogous, that case is instructive because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue.
Thank you again, Des, for
Compensation is
that.
available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of
Thank you again,
compassion,
April
but
Miller.
necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor. No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's
clear,
fine.
Your Honor.
While Mr. Luca is cleaning up, is there anybody that's going to be here in the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115 SC?
Your Honor, Patrick Riley on behalf of Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
Okay. And has anyone appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator.
Okay, while we're waiting, you
Okay, thank you. The
guys,
court deputy advises no response to the sounding of the
there's
halls.
no response, so they're going to win this
Well,
judgment by
let's-
default.
What's your intentions then in this case, Mr. Riley?
Your Honor, I've never had a situation where quite like this. So I don't think I'm obligated to give the Laundries 20 days from the time they were appointed as administrators ad litem to defend the action. But to avoid any future issues, I'm going to give them 20 days and then I'm going to file for a clerk's default.
Okay. And you requested a jury trial in your complaint, I believe?
I did.
Okay, so we'll then have to have a jury trial on the issue.
Yes, Your Honor, we would be prepared to proceed to trial on that matter quickly.
Okay, well, I mean, it's a little premature relative to no default, but are you looking towards November, December, or what was your trial?
Without my trial calendar here, Your Honor, I'm not certain, but probably more likely sometime in early 2023.
Okay. Well, I mean, hopefully for case management in the future, you can bring your trial calendar.
I apologize.
Yeah. Well,
Thank you, Jackie.
we'll wait.
Jakey 5, thank you so much. I appreciate it.
If someone appears, obviously, if someone appears, I want you all to go ahead and do the case management order and get deadlines set. And so that we'll get the case rolling. If you end up having a default, then we can set a trial. I don't think we necessarily need another case management. You know, we've got a November 14th, December 12th, then we'll, in the new year.
Your Honor, I can look at my calendar now.
Yeah. Well, I mean, I can't set a trial right this second because there's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed.
I agree with
the
that,
case.
Courtney.
I mean, obviously, if you decide not to proceed with the case, then you don't need to have it. But we'll call a jury, and we'll go from there.
Very well.
It's just, I'm trying to figure out, with all the other trials going on here and which judges are going to be here when, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
Oh, I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
So I will not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send my judicial assistant word that the default has been entered and a couple of dates on our trial calendar where you're looking for the trial to be had, and then we'll go from there. Assuming that there is a default, how many days of trial are you anticipating?
1 to 2 at the most. The witness list will be short.
We don't know
I
who that
suspect
woman
jury
is sitting
selection will take
behind
a little bit of
them.
time.
Well, that's why I was saying.
I would
1 to
assume
2,
they're
because I think
family
I can
members
try the
of
case
Gabby.
today.
Or Gabby's parents.
Okay. Anything else in the second case, Mr. Riley,
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much for being here and have a good afternoon.
Thank you.
Okay, so that's it, you guys. Nothing really done. The judge is going to be making a decision at a later date. Yeah, by what I just got from Gabby's parents' lawyer, I think he's concerned about putting it too far out because he wants this same judge. So this judge may be retiring or something because he's really concerned about putting it out too far. And that's why the judge had said that it's going to be up to others to make that decision. Thank you so much, Marie Burks. I appreciate it. Thank you to everybody who's given a super sticker, super chat. I appreciate the support. It helps keep the channel going. Thank you so, so much. Yeah, Gabby's mom was like broken. Yeah, I believe the blonde-haired girl sitting directly behind Gabby's mom was a friend of Gabby's. Yeah, I think that's what they're concerned about is another judge taking over. But right now, the first case is, I guess it's as far as I can understand, because it's hard to get the paperwork on these cases in Florida for some reason. But I believe the second case that they were speaking of has to do with getting all of Gabby's personal belongings and splitting up what was, what they had together, Brian and Gabby. That's what I believe. Don't quote me on that, but this is what I'm getting from that, is that's what that is concerning. Yeah, Gabby needs this judge. And I do think that this will go forward. It's just Florida law is different from a lot of other places. But I do think that Gabby's parents' lawyer did make some really good arguments. And I think the judge is leaning more on his side right now. He's taken it under advisement, so it's going to be a couple weeks before we find out if he's going to let this go to trial or not. Let's keep our fingers crossed for justice for Gabby and for her family. Cruella, what they're saying there basically is because Brian contacted them on his way home, he had to have said something to them about either probably a lot of things, but they probably knew at that point in time he was returning alone, and they retained a lawyer right away for him. So something was said for them to know that some kind of crime was committed and that Brian needed a lawyer. So they retained this lawyer. When he shows up without Gabby, it's quite obvious what crime would have been committed. Either he stole her van, he just deserted her, or he killed her. Either way, they knew that he needed a lawyer. I am damn well sure that his parents are not going to fork out that kind of money without knowing all the details. Yeah, I do believe they have some, but not all of it. Anything that was in that storage and stuff that they owned together, I don't think they have back yet. Yeah, and they did. They took that camping trip, and I think that's where I think that they were paranoid. I think that camping trip was a setup to be able to go somewhere where they weren't going to be overheard, to discuss what was going to happen. I absolutely will. It will be on my community tab. As soon as I know, I will post it there. Yes, absolutely integrity. Again, you guys, thank you so, so much for your super chats. I appreciate it. You're very welcome, Krella. Because today they didn't respond to the second case. So the Petitos will get that under default if nobody responds in the next 20 days. And the first case, it was a filing by the Laundries to dismiss the case. So for stuff like that, they don't have to be there. They should have been. If they have nothing to hide, they should have been. But staying true to form, this is what they do. There was some stuff already released about the notebook where Brian took responsibility for killing Gabby. I do believe I covered that in one of my other videos. Oh, there's been a few. There's been a few. Look at all the help that Letitia Stout got from her family when she had, when she murdered Gannon and then traveled with his deceased remains all the way to Florida. Her aunt rented her the car. Her daughter was with her, and other family members were there too. And I do believe that there's ones there that knew. So, I mean, it's not that it doesn't happen. But yes, Letitia Stouts is one of the first ones I covered on it. I don't know if I think the Petitos do have the van back because it was under Gabby's name, but I believe all the stuff that was Gabby's in the Laundrie home and in the storage, they still do not have. We still do not know that. Yes, and that's what I was basically saying is I think that they thought that they might have been, under some kind of surveillance, which they were. The FBI, I believe, set up cameras in the neighbor's backyard as soon as Gabby was reported missing. But they mistaked Brian's mother for Brian. So... yeah, and it shows intent to help cover it up. They were also moving money around, so there was like 25,000 or something like that in Brian's account. How did that get there? Why was it put there? Because Brian had no money when he was coming back from murdering Gabby. He had no money because he was using her card. So where did that 25,000 or 20,000 that was in his bank account come from? And why was it put there? Right? That's got to be thought about too. Obviously, he did not have access to that money on his way back, because then he wouldn't have taken Gabby's credit card or bank card, right? Yes, but if they, once they're disposed, they're going to have to speak. Oh yeah, they will be required. If this goes to trial, they're going to be required to be there. There's certain things that they don't have to be there as long as they have representation. No, I don't think it's uncharted territory, integrity. Just give me a sec, you guys. I think so too, Courtney. Yeah, I'm kind of still on the fence about that. This is one of the reasons why I think that they don't want to hand over everything, because everybody knew that Gabby wrote in that diary. So where is it? And if it's been destroyed, that's not going to look good. Right? All that could have been saved if they had opened their mouth. Diane H., I don't know where you're getting that, but let's not be sharing. If you're getting information from another platform or channel, that we don't share that here. Yeah, I believe they're accessory after the fact. Yeah, it's pretty sickening, you know, to know that did you guys see Gabby's mom's face when that lawyer brought up the baby incident? It's like, how low are you willing to go? You know, like that was a pretty low blow. And yeah, aiding and abetting, like there was charges. There was an arrest warrant out for him for using Gabby's credit card or bank card. And they knew where he was at that time. They knew he went to that reserve. I think they knew exactly where he would be hiding out till things calmed down a bit, in the hopes of maybe fleeing when things died down a bit, and then seeing to the extent of what was happening, so decided to just off himself. I do think that they were intending to get him out of the country. And he went to the reserve to hide out for a bit until things calmed down. I don't think they expected this to blow up the way that it did. I agree, Courtney. Yes, she was seen in some of her pictures writing in her diary when they were on that road trip. Yes, but I don't want, I know you didn't mention channel, but I don't want information being brought from other channels either over here. Unless it's talked about specifically here, then I don't want it brought here, because I don't know where that information is coming from, and I don't agree with it. So, and I don't think that it's up to any other lawyers to give that opinion because they're not involved in the case. That could very well be too. I think when they went back and got that car, I think they let him know how intense the search was going to be getting. Thank you, Cat H, for taking care of that. I'm over on StreamYard, so I can't see it. But yes, Jakey, I agree. I agree there. I mean, that's only my opinion, but I'm going to agree with you there. Yeah, April, I'm hoping that if they can prove that his parents were, like, to me, you guys, you got to think about this. On his way back with Gabby's van, he used Gabby's credit card or bank card because he had no money. He had access to no money. If he had $20,000 at that time in his account, why wasn't he using his own? You know what I mean? It's because I believe that money was put into his account to help get him out of the country. Yeah, and yes, I agree with that too, Ryan. I don't think they expected her body to be found as fast as it was. Thank God to those other YouTubers that seen that van, had picked up their van on their camera. Thank God for those. I wish I could remember their name. If anybody could remember their name, you can, I will allow you to post their channel name in chat. They drove by and they just happened to get Gabby's van on video. And that's where it came to where they had to focus their search on. So it's really thanks to them. Well, it goes against their right to remain silent. If they're making statements to their lawyer and their lawyer then presents that, that's not using your right to remain silent, because they are telling the lawyer, this is what our statement is. So that's a touchy point, but it can be used against them. Yeah, and that's why they couldn't get him out of the country, because of the massive search. I don't think they expected it to blow up the way it did. They can't plead the Fifth and then use a lawyer to make statements for them and hide behind that wall of the Fifth Amendment. The comments that they made to the lawyer that the lawyer then repeated can be used against them. Red and White Bethune, that's it. Thank you so much, Cruella. That is the name, you guys. If you haven't seen it, go over and check out Red and White and Bethune. They're the ones that were on their own little road trip, not expecting to come across what they came across. They were just going through these roadways too, and trails, whatever, looking for a place to stay. And just happened when they heard about this case, checked their footage and seen, oh my gosh, look at what we got. Thank God for them. So yes, if you haven't checked that out, go and check out Red and White Bethune, and check out their video on that. Yes, Red and White. Yes, thank you, everybody. Thank you, everybody. I've totally, you guys know my memory, so. Yeah, great people. And you can tell them so much respect for them. And I thank them for everything they did to, essentially, I believe it's because of their video that Gabby was found as quick as she was. So please send them our thanks, Integrity. The next time you're over there on their channel, you can let them know that I've gave them the biggest shout out. I wish I could give them more. They're just amazing, amazing, amazing. Yes, it was like, thank God that they took the time out of their, and they had kids and everything. I mean, to take the time out of their life to say, hey, we were in an area, let's search our footage and see. Like, thank God for them and for coming forward, for having the strength and everything to come forward and put themselves in the limelight the way they did. I just got all the respect in the world for them. Yeah, and I believe that's why they put the money in, and that's why the Petito lawyers said that they started moving money around. It all goes towards covering things up. Yeah, exactly. They are the reason why Gabby was found as quick as she was. Yes. Gabby Savior. Yes. That was debunked, Diane. That was debunked. They did not see anybody digging. That was debunked. And that's why I say, please don't put stuff like that in the chat, because it's been debunked long ago. The only thing that was caught, other than that van on the video, they got some of the inside of the front. They seen like a sombrero kind of hat. And they did catch a pair of flip-flops on the outside of the van. And they caught the door opening and closing as the vehicle was approaching. That's right, Ryan. And I believe that they were put there for a reason. And they were going to be the ones that came forward. Thank God they had the morals and values that they do to come forward and say, hey, we caught this. Thank God for them. Yes, please give them a big thank you for all of us here. Yeah, I don't know if that was just the, I know that was being talked about, integrity, but I don't know if it was actually the angling of the camera or not. I didn't really follow up on that. Like I said, it's a lot to keep hold of all these cases. I've got a lot of big ones that I'm covering. So I do know that there was talk of that. I don't know if that was debunked or not. I think, yes, again, you put it here. I do believe now, see, I don't like commenting unless I can say 100%, but I do believe 90% that it was debunked to a camera angle or something like that. I would have to go looking for that to find verified. So, okay, you guys. Yeah, that's why I think they were moving money around quickly, and a lot of things being done secretively. Did they allow them in? They had no choice because the police had a warrant. So to say that they're cooperating with the police, no, they did not cooperate until they didn't hear from their son. Okay, so they knew he had the new phone. They didn't report him missing until they stopped hearing from him. I believe that the day that they went and got the car, they alerted him to the massive search that was going on. Then they report him missing. Why would you report him missing after 2 days and the car's parked there? You know when he left. You know what I mean? No, she was not buried. What was I saying now? I forget. That's how well my memory is, you guys. Yeah, when they went to pick up the car. Okay, your son's been gone for 2 days. You said he went for a hike. So obviously you knew he left with stuff, or you would have been so concerned. Oh my God, he went for a hike. All he has on is a shirt, his shoes, his whatever. He's got no water. He's got no this. He's got no that. Oh my God. I would have reported him missing right away when he didn't show up back from the hike. Not go there, look for the car, find the car 2 days later, and then still wait to report him missing. There's no way. Okay, if it's in the police pictures, that's one thing. Then I will say that it's verified if it's in the police pictures, but I can't at this point verify it because I haven't seen the pictures. So me, myself, like I said, if there's people here saying that they were in the police pictures and it was missing, then that's what it is, but I cannot personally verify that. Yeah, well, they knew before then, Diane. They knew before then when he was traveling back without her, because that's when they hired the attorney. He hadn't even been home yet. They hired the attorney, I believe, on the 28th. He didn't get home until September 1st. So, and then he shows up without her. He's used her bank card. Okay, so if he's using her bank card, then he had no money. And it was a pretty known fact that Gabby was the one with the money. I think that really bothered him. But anyway, he had no money of his own, so he takes Gabby's bank card to get gas to get home. If he had $20,000 in his account, why is he stealing Gabby's card? Nobody else would have been able to use it because nobody else other than Brian knew the PIN, right? So I do believe that they knew, and that's why they hired the lawyer on the 28th before he was even back in Florida. And then they started moving money around, and all of a sudden he's back in Florida. He's got a new phone. I believe that they were in contact with him via this phone. All of a sudden he's got $20,000 in his bank account. He goes out to the reserve. They go and pick up the car. If he's not returned after his little excursion to the reserve, wouldn't you call, if that was your kid, wouldn't you call right away he hasn't returned and report him missing? No, they wait. 2 days later, they go, they find the car, and then they still wait to report him missing. No, they knew exactly what was happening. There's been quite a few. We're not going to mention other channels here, but there's been quite a few that have gone out there to her gravesite. Yeah, I believe they knew exactly where to find him. And I believe during this whole search, they knew exactly where they were going to find him. We don't know this, so we're not gonna. We don't know if the father handed the gun to him. We're not gonna mention other channels, please. But yeah, so, I mean, we're going to see, yeah, all the tax dollars spent looking for him when the parents, I believe, knew exactly where he was. Like I said, your son goes, and why wouldn't they have said anything too? If he left that house with a backpack on and all this stuff to stay a couple days. So he would have had to have water and food and all that. Why wouldn't they have reported? Like, what are you doing? Why are you going? They surely wouldn't have left the car there. They would have brought him there and dropped him off if he just wanted to hike for a couple days. No, I believe they knew exactly what was going on. You've been booted. Who booted you? Or it's your internet. One of the two. Yeah. So like I said, the day he doesn't come back from this little hike that he was going on, I would have reported my son right away. He's missing. I would have went and looked for the car. But they didn't. They waited a couple of days. They waited long enough gave him a couple of days to take off. So my theory is he probably was trying to get as far away as he could so then he could be flown out of the country or gotten out of the country somehow. 2 days later, they go and find the car because there's this search going on for Brian. You know what I mean? Like, it just doesn't make sense why they waited so long to report the car and then report him missing and then still not say nothing. During this whole search, knowing where Gabby was and knowing where Brian was. They hid it all. So I do believe, I hope that this goes to trial, you guys. Gabby and her family deserves justice. And I do believe that the mother and father did cover for Brian. I believe it 100%. The sister, I'm not so sure of. I don't think that she was involved in it. Hello, Joy. I don't think she was involved in it at all, but we will never know unless that comes out in a deposition. But they take him to a campsite so they can talk freely without being bugged, because I'm sure the parents, that would be the first thing that would come to my mind if my son was coming home with his girlfriend's van and there's no girlfriend and we know that he's killed his girlfriend. We're not going to sit around in the house and talk about it. We're going to go elsewhere where we know we can't be bugged, and maybe our house is bugged and everything else. So we're going to go somewhere where we can talk freely and discuss what we're going to do. That's what I do believe happened. I don't think that the plan was for him to kill himself. I think the plan was to get him out of the country. And I think that was plan B on Brian's part, to kill himself, because I think with the parents being in contact with him and telling him, look, they got this big search going on. Oh my God, there's helicopters. They're going through all the reserves. There's people outside our house. That's when I think Brian decided to take his life, because he knew there was no way getting out there now. Exactly, Marie. Why would they pick up the car? And then even when they got there and the car's sitting there with a ticket on it, why wouldn't they call the police right away? Why'd they wait another couple days? Yeah, and the fact that they found his remains after the police did, they knew exactly where to find him. And I think that they had somebody going and dropping stuff off to him, or they knew something. They knew. Yeah. Yeah, but when he went out there, who said that? Cat H. When he went out there and when they went to get the car, it wasn't flooded. And even being flooded, his body would have rose to the surface because of the body gases. If they had told him, if the Laundries had said, this is where we found his car, this is where he generally goes, because apparently they're the ones that hung up that rope swing and everything. So they knew where Brian would go. If they had told the police what they knew, then he would have been found. Yeah, me too, Joy. I'm still not convinced that he's gone. I battle myself with that. Well, thank you, Random Picks, for stopping in. Thank you, thank you. I appreciate you. Thank you so much. Yeah, there's no way the father shot his own son. Oh, I feel that he was going to try and escape. And that's why the money was put into his account. But something popped up. And that was the massive search. Yeah. There's still a lot of things there that don't make sense with him killing himself. I may do that, Cruella. I might. I've got so much that I've got to do now. There's updated reads that I've got to do. I'm still in the private reads, catching up on those. It's a lot of time. I'm one person, so I will try and maybe get that done. I don't know when, but as soon as time allows. Why I still think he's alive? Because of the pieces of what was found, being that it was a family member that identified his teeth, and being that he was shot on the side of his head that was not his dominant hand, and the gun not being there. Oh, absolutely. I will be streaming that if this goes to trial. He could have taken large lump sums out. I don't know, but he knew they were looking for him, so he already knew that they thought he was guilty. So he had nothing left to lose at that point by running. Well, thank you, Butterfly Dana. Oh, thank you, sis. Yeah, they're the most accurate that I have. And they're the ones that I connect to the most. So I am going to try and integrate them a little bit more and maybe use my other decks for clarification. I've asked my elders to add a few more cards for me. So I'm waiting because they're going to have to mail them to me. So I'm waiting on those too. Right, Christy, if you would like to donate, there is, I got to get over into, maybe sister, can you let Ryan know how to donate, please? There is a $sign, I believe, below. I'm on StreamYard, so I can't see right now, but wherever you type your comments, that you like the one you just typed below there, there's a $sign. If not, I have PayPal. So if somebody could put up my PayPal, please. So you can donate either way. Thank you, Ryan. I appreciate that. Yeah, they knew when he was driving back that he had offed her. Like, why hire a lawyer if he hasn't committed a crime? Can you also put the link, sis, for my PayPal? I think I have it somewhere. It's just to find it right now with all these windows open. Oh, let me see if I can find something here where they talk about. Yeah, so there's already a jury trial scheduled for this for August of 2023. But that doesn't mean that it's going to happen. And we're going to have to wait to see what the judge comes back with. He took it on advisement. So he'll give us his response to this. If it's going to go to jury trial, he'll let us know within the next 2 weeks. So yeah, that wasn't Bordolino that you guys seen. That was Matthew Luca. Oh, sorry guys, give me a second, please. Sorry about that, you guys. Amazon for my border. Oh, thank you, Ryan Christie. I appreciate you. Thank you so much. And thank you. Butterfly Dances. Sorry, I would stick around. So interesting, but I need a food starting later. Okay, you guys. Take care, Butterfly Dana. Thank you. Integrity says he's playing devil's advocate. He could have lied to his parents and told them it was an accident. Either way, they know that she's dead and he killed her. Whether it's an accident or not, if it was an accident, police should have been called back then, where it happened. By running from that and leaving her dead without telling anybody. Yeah, there's a lot that we don't know that the FBI has. That will all come out at trial because they subpoenaed the FBI. Yeah, and Jakey states too, he would have left the van if they split up and he would have flown back like the last time. Nobody leaves a young girl in the wilderness. And so the parents knew. And he had just flown back and met up with Gabby again just to kill her. So did he see something? Maybe when he was cleaning out the storage locker, did he maybe see something that she had wrote or whatever? Like, we don't know what sparked this, right? And it was only a couple days after he flew back to meet back up with her after going to Florida to clean out their storage locker. So did he happen to find something in that storage locker that set him off? We don't know. It would come out in the trial. Because we only got bits and pieces of what was written in his book that they found. Well, Deborah, what they're saying, Deborah says, thank you again, Ryan, for that. I appreciate it. Deborah's saying, am I understanding this? If you don't see your child murdered, you're not a victim entitled to compensation. Please help me understand this. No, I don't think that's what they're, well, that's what, it's an analogy that the defense used in their rebuttal. But you're absolutely still a victim, even if you weren't there to see your child murdered, you're still a victim. But I think he was using that for different purposes, trying to say, like, look, this is what happened to this little baby, and it wasn't like the defense said it was, and blah. It was just sickening. But absolutely, they're entitled, especially if Brian's parents knew what he did. And I do believe they did, because they hired a lawyer for him before he even reached back in Florida. Ryan Christie says, oh, I love this channel. I found it by mistake and have been catching up for about 6 hours a day. Aw, thank you, Ryan. Oh, thank you, K Mitch. Yes, thank you for the support. I appreciate it. Flyer B is leaving too. Take care, Flyer B. I'm going to be wrapping this up shortly. Ryan, you're safe here. I have the best mods around, and it's a safe place. I don't put up with the bullying or attacking, anything like that. Safe place for you right here, my dear. And it's all factual. I don't allow gossip and stuff that's coming off of other channels that's not verified. Only verified information here. So thank you so much for becoming a subscriber and for your super chat. I appreciate it. Yeah, this has to go to trial. Like, the truth has to come out. Well, that's a given integrity, because who in their right mind would do something like he did? But I think there's mental health issues all around with that family, because knowing what your son did, and I do believe they knew, like the Petito lawyer said, there's so much circumstantial evidence that proves they knew. To know that your son did this, and then go one step further, block Gabby's parents as they're frantically texting them and messaging them and going on Facebook and, where's our daughter? Please help us. Please help us. And then you just block them. You block their phone calls. You block any kind of contact that they could have with you. And you're the only one that can give this family answers, and you block them. That is cold-hearted. There's mental issues all around. Who could do that? Yes, I do have mini reads on Sundays, every Sunday, 11:30 a.m. Eastern. Mini reads for you guys. There you go. Yeah, I actually, since my sister, there was actually something that happened last Friday that I had no idea about, which came out in the cards on during Dee's Dauntless Detours. In her mini read on Sunday, there's things that come out in there that I didn't have no clue about. She didn't even know about this. Something that was sent to her months ago, she had no clue of either. It came out in the read, so. Well, you're more than welcome, Ryan. Every Sunday, 11:30 a.m. Eastern. I do the mini reads for everybody. Yeah, that's very well possible. Integrity too. I don't think she was going to leave him out there, though, because she was scared of being alone. She did not like being alone. She would not drive alone. She would drive short little distances alone, but to do anything, even driving that van back to Florida, she wouldn't have been able to do that alone. She did not want to be alone. She had a fear of being alone. And that's one of the things her dad had said, and or her mother, one of the two. So I don't think she would have left him out there, but I think that he may have came across something that she wrote that suggested that she was thinking about doing that. Yes, God willing, the truth comes out. It needs to come out. Oh, thank you, Marie. Yes, bad roots, bad tree, bad fruit. Hello, CLH, and welcome. So you guys, I have updated reads that I do have to do. There's going to be one on, let me just see. I've done the Dylan Rounds updated read. What was the other one? Angel Fagan. I've got to do an updated read on her. And let me just check it. Maybe if I put my glasses on. So Angel Fagan. Oh, the other one I just... Hang on a sec, you guys. I will find it. Angel. I did Dylan. There's another one. Jaden Penno Tom set is so I got those two updates to do. I promised I would do them, so I do have to do those ones. And then maybe I will start digging in again to some of these ones here now that it's being out there again, and maybe we'll even get an answer about what the judge is going to decide. I hope so. Okay, wait a minute. Check my messages. I got my phone off, so hang on. Oh, yeah. February 6th read. The mini reads on February 6th. Thanks, Des, for bringing that up. In the mini reads on February 6th, I told Daring D that she was good. There's something coming in written form and it's not going to be good and blah, blah, blah. I don't want to go into all the details of it. And it was a couple days later that she did. She got somebody sent her an email, but she never seen it until this past Friday. And it was from back in February. But February 6th on that Sunday, I told her, you're going to have something written. There's going to be written communication. It's not going to be good, blah, 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 whatever was said. I don't want to get into all the details, but, and she did get something written via email a couple days later, and it was not good. So, yeah. And then on Sunday, this past Sunday, it was brought up again, and I had no idea that she had found it on Friday. I only found out Sunday. CLH, Aiden Clune, I have not even heard of that case. A Mia update. She's healing well so far so far, so good. Thank you for all your prayers and my grand fur baby. Your support has meant the world to me. Aw. I told you the other day she just needs extra love. Extra love, that she would be fine. So I am so happy to hear that she is healing now well. She'll be up and running around again in no time. But yeah, Aiden Clune, I have not even heard of that case. And I don't know if it's a big case. I don't know if I am able to take on another big one, but I will write it down. I do have quite a few waiting for the free public reads. I can only do so much at a time. Yeah, and I was shocked. Yeah, it was like, oh my God. So the mini read that I had done for you before I seen that email made perfect sense. Aiden Clune went missing in an area not far from where Dylan went missing. Really? Well, if it is some way connected to the Dylan Rounds case, then how about I will do a mini for myself and see if I can pick up anything. And if I feel like it's going to be something big to even help his case or Dylan's case or both, then I will definitely do it. But I've got to get a feel for it and see. Please don't say anything. If you want me to do that, please don't say anything else about the read, about Aiden Clune before I do the read. So a month before, okay, that's, don't tell me anything else, please, about it if you want me to do a read. Because I don't like having much information. So the same area as Dylan. And how old was he? I don't want any more information than what I asked for, please. How old was he? Does anybody know? You're very welcome, CLH. Was he young too? And was he a farmer? That's all I need to know. CLH, do you know how old he was and if he was a farmer out there also? That's all I need. That's all the information I want on it. Cat H says yes. 18 or 19, not exactly the same area, not a farmer. Okay. Not exact area? Okay, that's all I need to know on it. Marie Burks, I have done 2 on Dylan Rounds. I did one about 2 weeks ago, and I just did an updated read on him. Marie, I did. I just did an updated read on him. Okay, so Aiden, I think he was 19. Okay, 19. Okay. So same age as Dylan. Wow. Okay, that's all I need to know on it. Now, where's my book? Oh, my God, it's right in front of me. Okay, so what's coming up, you guys? The The 30th of June, Barry Morphew, and I'm going to be streaming it. Barry Morphew is going to be in front of Judge Murphy again for arraignment. Right now, he's out on his own recognizance, and apparently he's flying around Florida and everything, which I find really odd since he's been released on bond. It may be on his own recognizance bond, but how is he able to leave Colorado and go to Florida when he is on a bond? There's something really fishy going on with this case, you guys. Really fishy with the Barry Morphew case. He's going to be arraigned on the trying to influence a public official and the voter fraud. That is happening on Thursday, June 30th, and I will be covering that live. I am allowed to stream that. It's an arraignment. I'm allowed to stream it, and Barry has to be there. So I will be covering that. It's going to be 11 a.m. Eastern that the court starts, so I'll go online about 10:45. So 10:45 a.m. on the 30th for Barry Morphew. That's the next one coming up. After that one, you guys, let me just see here. Troy Drivers has his preliminary hearing on July 5th. And then Trezell and Jacqueline West have a readiness hearing on July 15th, but we cannot stream that. And then their Trezell and Jacqueline West trial is supposed to start July 25th. We don't know if that date is going to be going ahead yet, but that's as far as I know right now. They have just had their charges have been upgraded in the deaths of Orrin and Orson West. So I don't know if that date is going to be vacated and it's going to be pushed further out now that they are charged with the murders. And then Letitia Stout is back in court on July 28th, and I will be able to stream that one also. And that's when they're going to have everything back from the evaluation. Yeah, like, it's like, how does this guy keep doing whatever he wants to do and is like, I don't know, you guys. I'm so fed up with the Colorado. Let me just see here. Yes, I hope they find Suzanne too. Yes. So I keep telling her, you can't keep stuff from me because it'll come out in the reads anyway. Yeah, and it's like Barry seems to do whatever Barry wants to do and never held accountable. It's like, wow. And apparently, you guys, here's another one. He was with Shoshana. What? He was with Shoshana in Florida. Storm warnings in Ohio. Batten down the hatches, anybody in Ohio? Absolutely, Cruella. Thank you. Justice for Suzanne. Absolutely. And I do feel she's going to be found, but it's not going to be pretty. When the truth finally comes out about all that, it's going to be, I don't even want to think about it. Okay, so with that being said, you guys, I want to thank you all for being here. I want to thank you all for your super chats and super stickers. Thank you so much for helping to support the channel and me being able to put aside more time to be able to do that. That helps do that too and bring more content to the channel. So thank you for your super chats and super stickers. Thank you for your subscriptions and memberships. I want to thank each and every one of you for being here and sitting through all this today. It was hard at times, but justice will prevail. So let's keep our fingers crossed that this judge does send it to trial. And Gabby and her family finally get the justice that they deserve. Okay, so with that being said, and my mods, thank you so much for everything that you guys do. You guys are the best. Okay, so until the next time, you guys, please take care of yourselves. Stay safe. Love yous to the moon and back.